think it's part of the hiring process before the company launches into engaging somebody to work for them. They first of all need to take a step back and think about what sort of work this individual will be required to carry out and how will the arrangement work in practice. Once they've done that, then the next step is to think about whether or not the person will be engaged as an employee, a contractor, or some other type of worker. And once that's been determined, then it's for the company to decide on how they're going to work with that person and engage them. If it's as an employee, it'd be using an employment contract, and if it's a contractor, you would usually have a consultancy agreement. Now, the reason why it's important to work out somebody's employment status at the outset is that employees have much more rights than contractors, so they also have employment rights around discrimination, rights to holidays, sick pay, and after a certain amount of service, they've got unfair dismissal rights. In addition to that, from a tax perspective, it is for the company as the employer to make deductions for income tax and national insurance from employees, and also pay employers' national insurance. Now, the flip side of that is for a contractor, that person will be responsible for their own taxes, and generally they wouldn't have any rights other than what's set out in the contractor agreement. Now, determining somebody's status isn't just about what it says on paper. It is really about how it works in practice, and that's why, as I said, it is important at the outset to think, how will this relationship work? So there isn't one factor that would indicate whether or not somebody's an employee or a consultant, and the courts and the tax authority would look at everything in the round. Generally speaking, employees have got a requirement to carry out any work that they're given. They're also required to carry out the work personally, and the company has got control over where, when and how the work is done. Now, in contrast, a consultant can turn down work. Usually they're engaged short-term on a project basis, and they have the flexibility usually to say where, when and how the work's done. So those are the key things to think about at the outset. Well, a bad leaver clause is a term that might be in an employment contract, or it could be in a shareholders agreement, or some other document whereby the company is providing a benefit to an individual, and it sets out the terms on which that benefit might be clawed back by the company. So in the case of an employee or a partner that's going to be granted shares, there might be conditions attached to that whereby if that individual leaves the company under certain circumstances, they will be treated as a bad leaver, which would then entitle the company to claw back the shares that had previously been granted. Now, the type of circumstances that might be included would be gross misconduct, but it might also extend to somebody that's a poor performer, or certain other agreed situations between the parties, and that's when the bad leaver rules would come into play. Well, from an immigration perspective, any individual that's an EU national can come to the UK and work without any additional approvals. But for companies that maybe wish to send somebody from outside the EU, for example, from North America or Asia, if those individuals will work in the UK, then it is necessary to obtain visa approvals. Now, there's different ways of doing that. Where you've got a company that's setting up for the first time, they can apply for what's called a sole rep visa. And that's where a senior individual from the parent company abroad would be sent to the UK to set up the UK business for the first time. Now, as part of the conditions for that visa, the person does need to be at a senior level within the parent company. The company in the UK should not have started trading, and this individual should be the first person that's employed by the UK company. Now, that individual, if they meet the conditions, will be granted a visa to stay in the UK for up to 5 years, and then after that will be required to return to their home country. An alternative route where a company decides to engage somebody on the ground in the UK, first of all, is to obtain what's called a sponsor licence. And that's a different route whereby Once a license is obtained for the company, it can then bring individuals abroad who meet certain criteria. And unlike the sole rep visa, potentially those individuals could obtain permanent residence in the UK. Often clients will come to us who are set up for the first time and say, we'd like to engage this person as a contractor because it's easy and we don't have to pay any taxes, anything like that, and the person's responsible for their own administration. It is possible to work on that basis provided you do treat the person as a contractor in practice. So that means that you do have to ensure that they have the control and flexibility over the relationship. Now, if the relationship begins to change, whereby that person is working with you, more like an employee, then there will be a risk that that person could obtain employment rights and potentially would have claims against the company for holiday pay, national minimum wage, and other employment matters. But more seriously, from a tax perspective, the company could be found to be liable for any unpaid income tax and national insurance contributions which that individual as a contractor hasn't paid, since it is the company in the first instance that's responsible for making deductions if somebody in reality is an employee. Now, on top of that, there would also be a further liability of employers' national insurance of 13.8%. So it can be quite a significant amount, and it is important that when you are working with somebody as a contractor, you make sure that that in practice that's how you treat the person. Many clients ask if they can take on interns and what's the legal rules around that, including whether or not they have to pay the intern. Well, from a legal perspective, there isn't a particular category of person known as an intern. Somebody is either an employee, a worker, like a casual worker, or a contractor. So the concept of an intern is really just somebody's job title. So it depends on what the legal status is of the person. If you're engaging somebody with a requirement that they have to carry out work and do that personally, and there's a commitment around that and you control the person, then it is likely that that person would be treated as an employee and you would have to pay them national minimum wage, notwithstanding that you're calling them an intern. If the individual doesn't have a requirement to carry out work and they're really there to assist you, now and then, they might possibly be categorised as a volunteer, provided you're clear that there isn't an obligation for that individual to carry out work. Either way, I think it is important that you do have an intern agreement in place that sets out what the parties' intentions are and also ensures that the company's interests are protected. For example, their interests in confidential information to make sure that the person working for the company can't take advantage of it.